Kyle Rittenhouse trial tonight as defense attorneys launch another attempt to declare a mistrial.
This as the jury continues to deliberate their verdict for a second day. This morning, the jurors asked to review some of the video evidence that was presented during the trial. We saw several different angles that show Rittenhouse engaging with protesters in Kenosha that night, including the moments when he shot the three men. Rittenhouse's defense say they received a lower quality version of those videos. They were not given the version that the prosecution had. They say if they had seen a more detailed version of the video, they would have approached this case differently. Prosecutors argue the highest quality video was already played during the trial without objection.
6 U.S. Marshals blocked the exits. Judge Caldwell warned of arrests, and Trump's lead attorney bolted mid-sentence. That's not TV. It happened in federal court. In the next minutes, we'll lay out how a secret DOJ submission about witness safety cornered the defense, and why their dramatic exit was followed by a fast "just kidding" filing for mistrial and recusal. If you've wondered how courtroom theatrics collide with courtroom power, this is your front row seat. No fluff, just the receipts on what forced the door shut and the strategy switch on. Why would veteran lawyers try a ghost exit when 6 marshals can turn into human doorstops? Because for about 10 seconds, they thought the rules of gravity didn't apply to them. Judge Caldwell is mid-sentence, calm but firm, and Robert Sterling rises like it's time for lunch. 2 colleagues pop up with him, folders clutched, eyes darting. The room stops breathing, pens hover, the clerk freezes, and the gallery, even the guy who always coughs, goes silent. Sterling says they can no longer proceed and tosses in that the court has abandoned all pretense of impartiality. Bold words for a man who's edging toward the exit like it's a fire drill. Then comes the snapback. Caldwell warns of arrest and contempt. 6 marshals spread out, wide stances, clean suits, no smiles. They're not rough, they're doormat. 6 bodies, 3 exits, no escape. It's like bouncers at a club for lawyers who forgot there's still a cover charge called decorum. Walking out mid-ruling isn't edgy. It's a foul on the first play. Federal court runs on order. Speak when recognized, sit when told, and never try to stage manage the judge's sentence. Doing it during a live evidentiary ruling is rare enough that analysts call it career suicide. You're not protesting, you're begging for sanctions. And the judge showed why. She went step by step, warning, threat, physical barrier, because a federal courtroom protects the record like it's gold. No chaos on the transcript, no theatrics in the footnotes. You want drama? Go argue at a press conference. Contempt is the judge's hammer. Direct contempt happens in front of the bench, in real time, and it carries instant penalties. That attempted walkout, classic direct contempt territory, because it was open defiance during proceedings. Judges use it not to flex, but to guard the process. Keep the case moving, protect the jury, and stop the soundtrack of political theater. And yes, you can get fined, cuffed, or both. Not because the judge is mad, but because the law doesn't work if anyone can invent their own intermission. Now, the defense called it a principled protest. Sure, except the signs point to a pre-game plan. The exit was timed. Right after Caldwell allowed 847 pages of new government evidence that tied up contacts and cash the defense swore didn't exist. Media folks were parked outside early. Conservative commentators were already tapping out. Judicial tyranny takes before the hallway even heard footsteps. And the kicker? Within 30 minutes, Sterling's team slid back in and dropped emergency motions for mistrial and recusal. If that's not premeditated, I'm the Easter Bunny. Judges have seen this show. Lawyers who chase cameras earn sanctions, not standing ovations. Courts have slapped fines for stunts, ordered apologies on the record, and even suspended counsel mid-trial when antics threatened the case. When a courtroom starts to feel like a circus, the bench becomes the lion tamer. You don't need a whip when you've got the marshal service and the power to appoint shadow counsel if a team goes rogue. Caldwell even floated that. Insurance for the 6th Amendment if Sterling kept testing the fence. So no cuffs, not yet, but exits sealed, threat of arrest live, and a bright red line on the floor. The law literally shut the doors. The message landed. You can leave any room you want, except this one. Not like that. Not today. Which brings us to the one question that kept buzzing even after the marshals relaxed their shoulders. What spooked them enough to try the most dramatic bathroom break in federal history? If this was a protest, why did Sterling sprint back to file paperwork like finals week panic? because something in that sealed pile screamed, "Stop the show." The judge confirmed a sealed ex parte submission from DOJ, flagged for security and witness safety, and hinted at sensitive intel. That means one side walked into chambers with receipts the other side couldn't touch. You don't do that for parking tickets. You do it when lives, sources, or ongoing operations could get burned. And yes, it smelled like a cooperating witness about to talk. Here's the crunch. The defense can't see everything, but the consequences land on them anyway. Options close up like a cheap umbrella in a storm. The judge starts floating tougher measures: juror sequestration, tighter movement in the courthouse, stricter gag orders. That's not ambience, that's pressure. Sequestration tells the room this is delicate, maybe dangerous, and the jury needs a bubble. When you hear that word, you don't plan a press conference. You start praying your theory still has legs. Ex parte security filings are the rare birds of federal practice. Judges allow them when disclosure risks harm, tips off tampering, or exposes classified methods. They're sealed because you can't protect a witness by printing a map to the witness, and they kneecap the defense's counter moves. You can't impeach a timeline you can't see. You can't fight a proffer when the details live behind black bars. Defense counsel still gets a path to challenge later, but not in real time. Not with a timer ticking and a witness under protection. A cooperator can blow up a story faster than a bad alibi. Think timeline checks that match phone pings, document receipts with timestamps, and wire confirmations that tie money to orders from the top. That's not vibes, that's linkage to the principle. If witness 14, under protection since October, walks in with encrypted messages and bank trails, the whole no direct tie theme turns into confetti. And guess what happened 96 hours before that scheduled testimony? A dramatic walkout that looked a lot like a Hail Mary to stall the calendar. So the pivot looked like this: exit for drama, re-entry for paperwork. Sterling's crew charged back in with emergency motions for mistrial and recusal. The language hits the usual beats: judicial bias, prejudicial atmosphere, due process concerns. It's less about winning today and more about planting flags for tomorrow. You stack objections, you mark the moments, and you say the magic words on the record. If the verdict goes south, you want an appeal route paved and freshly painted. That combo, mistrial plus recusal, builds a scaffold for appeal. You argue the judge's handling of sealed materials shaped the jury's world. You claim the security posture tainted neutrality, and you cry due process like it's a fire alarm. Even if the judge denies it, and she will, the points survive. Appellate courts love a tidy record, not a YouTube rant. Prosecutors weren't shy. They pushed for sanctions and daily fines, pegged at $50,000, saying the walkout was pre-planned for the cameras. They pointed to crews arriving early and social media hot takes about judicial tyranny landing before the dust settled. Translation: the government thinks this was theater dressed up as principle, and if it was theater, they want the ticket price to hurt. So the mini payoff is clear. Fear of a cooperating witness explains the flight. The crawl back was to lock in mistrial and recusal plays, and those emergency filings were triaged to salvage leverage after the escape hatch jammed. With doors closed and filings flying, the bigger question lands: is the courtroom a stage or a spine?